My name is Harry, and I'm from London.
Meghan Markle here.
Now, I think this is where we're getting a little bit toward the heavy squat thing. Okay? So, there's this here. The mission continues. Some people need to be afraid, very afraid. Okay? I think I looked for this article. This is just a screenshot. And that's what I saw, and that's the one that I put on my community. But we're along with that prayer as well. Okay, Prince Harry granted access to secret Levison records and Daily Mail hacking claim. Okay, and I believe this is Prince Harry granted access to secret document for hacking claim. Okay, so there's this here, but I was trying to archive it, but it seems like someone had already archived it. This page was last archived 10 hours ago. So someone quickly archived it. So I will share the archive link. Okay. So let me close this. I just wanted to show you. Let's close that. I don't need it. I'm just gonna keep with the archive version. Okay, so let's read it, and then I'll go back to Twitter and then read some of the comment. Okay, so the Duke of Sussex and 6 other high-profile claimants, including Sir Elton John, Liz Hurley, and Doreen Lawrence, want to use the documents in their lawsuit against Daily Mail publisher Associate Newspapers, alleging phone hacking, blagging, and other unlawful information gathering. Okay? How long is this? Oh, not that long. That's good. Okay. Prince Harry has successfully secured the release of confidential documents from the Levison inquiry as part of his phone hacking case against the publishers of the Daily Mail. The decision permitting the Duke of Sussex to access the file was taken by Culture Secretary Lucy Fraser. Harry and 6 other high-profile claimants want to use the documents, which detail payments to private eyes, to support their case against Associate Newspapers. The group, which includes Sir Elton John, Liz Hurley, and Doreen Lawrence, have filed a lawsuit which make allegation of phone hacking, blagging, and other unlawful information gathering. Although the claimants had been given leaked copies of the documents, a judge ruled they could only use if the government approved their release. In a joint statement, Home Secretary James Cleverly and Ms. Fraser said, quote, "We do not consider that it is necessary in the public interest to withhold these documents from any disclosure or publication. The government notice changes the restriction order imposed by Sir Brian Levison following his 2012 inquiry into British Press Standard." The Associate Newspapers tried to stop the files being released, claiming they had provided the Levison inquiry with the ledgers of payment on the understanding they will remain confidential. So many things going in my mind right now. Okay, the decision has been welcomed by Prince Harry and the other claimants bringing the litigation. Associate Newspapers deny all the charges. At an earlier hearing, their lawyers had argued the case was being brought too late, but this was rejected by a judge who concluded they had failed to deliver a knockout blow. One of the things that I was thinking is that there was supposed to be a continuation of the Levison inquiry. They never pursue it. We don't know why it was never pursued, but these people, they continue, especially Harry in particular. Okay, the same group of people, they may have be an other name of I don't know, businesses or newspapers, because I think there's some papers that change name or whatever, but it's the same group of people who still on Harry's case. So if the same group of people were under the Levison inquiry and they won't leave him alone, I don't know. Harry, do what you gotta do, and all I could do is pray for you, and may you be successful. Okay. At an earlier hearing, the lawyer had argued the case was being brought too late, but this was rejected by judge who concluded they had failed to deliver a knockout blow. Prince Harry recently settled his outstanding claim against Mirror Group newspaper for undisclosed sum. In December 2023, he won a substantial part of his claim that he was the victim of phone hacking and other illegal practices by Mirror Group. Okay, so the part that he wanted to hear, he got it. His part in court, the court heard his claim, and he was vindicated. The court found him to be true. Okay, he won his case. So the others, just settle it and then move on. But Harry hasn't always had success in his high court challenges. He recently lost his legal challenge against Home Office. That was a review. Okay, that's something I want to share with you also in this tweet video regarding his security over the provision of his taxpayers funded security. Okay, but the thing is that he wanted to pay for it. Okay, but I don't know how it plays into the thing. Okay, he earlier lost a libel case against Associate newspaper over on other COVID and about the same case. Okay, so there's that. I mean, when you have almost everyone at every station, every basis, that's what I mean. It's every station, every basis, they all are the same group. They're looking out for each other. And you have Harry, an outsider, who's fighting them. What do you think is going to happen? They're all going to band together to make sure he lost. They're not going to out each other, the others. So that's that. Let's go back. Is that the one that I was reading? Is this one that I was reading? Okay, Piers Morgan needs to be very afraid. Look out for him lashing out at Prince Harry today. Oh, did he? Okay, I didn't I don't follow him, so I will not know. And I wasn't really too much on Twitter. Okay, so this is a prayer that I put out for him. Prayer warrior. As prayer warriors, we must remember that no matter how hopeless a situation may appear to us, God gave us power and prayer to do something about it. There's the thumbs up. That's an ad. Okay, so let's go to the next tweet. Next tweet, and this is that. All right, so that's the same one that I just had here. Okay, you F around and find out you did a disservice to yourself by illegally snooping in Prince Harry's and others' business. Ball files. Don't cry now, UK tabloid trash medias. Face the music like the despicable scumbag you all are. 2024 this is the year of the truth. Okay, so this is the thing here. Prince Harry granted access to secret Leveson records and Daily Mail. So it's similar to the things that I just read, is that the judge said if the government give him access to this file and he wants to file a lawsuit based on those information, he can. But if it was leaked to him, the court will not recognize his case. Okay, so keep that in mind. I just read that particular article. All right, so this is a GIF. It's the truth. Deal with it. Okay, so let's read some of the comment. Go get them, Harry. Let's go march. Okay, so that's an ad, and that's it. So now the next thing that I have here is regarding Ravic. And this tweet, I shared it with you, but the only reason I put it back on the list is because it has the court documents. Okay, this part is quite interesting. The court saying any departure from policy is allowable and procedural unfairness is also okay because they can do shit. Okay, so I'm not even gonna read this because I read it in another video. So this is the part that I'm more interested here. Okay, that's an ad, so let's black this. Okay, the court has found that there hasn't been any unlawfulness in reaching the decision of the 28th February 2020. Any departure from policy was justified. The decision wasn't irrational. The decision wasn't marred by procedural unfairness. Prince Harry was unsuccessful. This is the file which I have here, and I have some of them open. No, I did open it. Okay, so there's this here. This one is about, this is what I'm saying, it might be more than one video. That's a lot of reading. Okay, so how can I do this? Let me think. I'm a little bit curious about it. I want to know what it says. So let's see here. All right. So this is the cover page. Before Mr. Justice Lane, between the King on the application of the Duke of Sussex and Secretary of State for the Home Department. Okay. Keep in mind, this is not a lawsuit. Okay. This is not a lawsuit. This is a review. Harry wanted the judge to review the case that Home Office did not want him to get the same security that he needed, because there have been a lot of threat against his little family that he just created.
But there were many serious, credible threats against Meghan, were there, emanating from the far right?
Absolutely. If you'd seen the stuff that was written and you were receiving it, the kind of rhetoric that's online, if you don't know what I know, you would feel under threat all of the time.
So you were convinced that there was a genuine threat to Meghan's life on on more than one occasion, on several occasions?
We had teams investigating it. People have been prosecuted for those.
And, the media in the UK keeps gaslighting things. The media in the UK keeps gaslighting things.
Justifiably cruel to them.
Well, Tis, let me just pick you up again, because facts are important. I know you like a narrative, but facts are important. When I broke the story about the move from Toronto to Los Angeles,
much of the negativity towards the couple is coming from within the royal family. The royal family and staff of the royal family are the ones that are very often leaking these stories to the press.
Facts are important. When I broke the story about the move from Toronto to Los Angeles, COVID had already struck and Canada was about to be locked down. And my royal sources,
much of the negativity towards the couple is coming from within the royal family.
Expressed, and including people close to the Queen,
from within the royal family.
Real disappointment that Harry and Meghan decided to flee to Hollywood rather than come back to their beautiful £3 million publicly renovated cottage mansion at Windsor. They had a choice, Tess. They chose to turn their back on the United Kingdom.
Began to address Granny about the 5 options. Your Majesty, you've seen the 5 options? Yes, she said. We all had. They'd been emailed to us. 5 different ways of proceeding. Option 1 was continuance of the status quo. Meg and I don't leave. Everyone tries to go back to normal. Option 5 was full severance. No royal role, no working for Granny, and total loss of security. Option 3 was somewhere in between. A compromise, closest to what we'd originally proposed.
They chose to turn their back on the United Kingdom.
Everyone assembled that, above all, I was desperate to keep security. That was what worried me most, my family's physical safety. I wanted to prevent a repeat of history, another untimely death like the one that had rocked this family to its core 23 years earlier, and from which we were still trying to recover. I'd consulted with several palace veterans, people who knew the inner workings of the monarchy and its history, and they all said option 3 was best for all parties.
They chose to turn their back on the United Kingdom.
Meg and I living elsewhere part of the year, continuing our work, retaining security, returning to Britain for charities, ceremonies, events.
They chose to turn their back on the United Kingdom.
Sensible solution, these palace veterans said, and eminently doable. But the family, of course, pushed me to take option 1.
They chose to turn their back on the United Kingdom.
Barring that, they would only accept option 5. We discussed the 5 options for nearly an hour. At last, the bee got up and went round the table, handing out a draft of a statement the palace would soon be releasing, announcing implementation of option 5. Wait, I'm confused. You've already drafted a statement? Before any discussion?
They chose to turn their back on the United Kingdom.
Before any discussion? Announcing option 5? In other words, the fix was in this whole time? This summit was just for show?
They chose to turn their back on the United Kingdom.
Summit was just for show? No answer.
on the United Kingdom in the middle of an unprecedented health crisis to go and set up shop at some $18 million mansion owned by Tyler Perry in Hollywood. So that is the fact.
Turn the narrative.
Much of the negativity towards the couple is coming from within the royal family. The royal family and staff of the royal family are the ones that are very often leaking these stories to the press.
Health crisis to go and set up shop at some $18 million mansion owned by Tyler Perry in Hollywood. So that is the fact.
Turn the narrative. What does that say about Britain and the British press? Let's not put all the blame on Meghan and Harry. Perhaps she didn't feel that welcome in the first place.
Piers, if you want to be private, go back to America and live privately. It's pretty straightforward.
Perhaps she didn't feel that welcome in the first place. We've already discussed the disparities.
Do you have any idea what the Hollywood press is like?
That welcome in the first place. We've already discussed the disparities.
Do you have any idea what the Hollywood press is like?
I think they're probably more gentle on Meghan than we were.
Oh, well, you're delusional. You obviously haven't read TMZ lately. I mean, if you think that any Hollywood actor gets an easier time from the press in Los Angeles.
I have a lot of sympathy.
But I have sympathy for Meghan.
I thought we were talking about Camilla, but then...
Yeah, we are talking about Camilla. And actually, can I move the conversation?
Okay, so keep that in mind. This is not a lawsuit. Okay, I skip a whole bunch of other things. Hearing dates 5/7 December 2023. Confidential drafted judgment circulated 1 February 2024. Approved judgment redacted for the purpose of publication. So they remove some information here. This judgment was handed down remotely at 10:30 a.m. on 28 February 2024 by circulation to the parties or their representative by email and by release of the National Archives. Okay, Mr. Justice Lane, the claimant challenges by way of judicial review the decision of the Executive Committee for the Protection of Royal and Public Figures, that's RAVEC, communicated in a letter of 28 February 2020 that as a result of his change and status in the royal family, he will no longer be provided with the same degree of publicly funded personal protective security by the police when in Great Britain. Ravic's decision followed the decision of the claimant to cease to be full-time working member of the royal family.
But the family, of course, pushed me to take option 1. Barring that, they would only accept option 5. We discussed the 5 options for nearly an hour. At last, the bee got up and went round the table, handing out a draft of a statement the palace would soon be releasing, announcing implementation of option 5. Wait, I'm confused. You've already drafted a statement? Before any discussion? Announcing option 5? In other words, the fix was in this whole time? This summit was just for show? No answer.
Carrying out official duties on behalf of the sovereign. In his first witness statement, the claimant said that my wife and I felt forced to step back from this role and leave the country in 2020.
Wait, I'm confused. You've already drafted a statement? Before any discussion? Announcing option 5? In other words, the fix was in this whole time? This summit was just for show? No answer.
Remember the Sandringham meeting where the family, the royal or the firm, should I say, I don't know. It seems like at that time it was the firm that was talking. No, nothing about the family part. Even though it was family who was gathering at the Sandringham meeting, but it seems like they were making it as a business part. This is the separation Harry keep on wanting it. So, and that Harry had said in his book, they had already planned a statement to be made public. Meanwhile, before that, he spent, I don't know how long, maybe hours discussing the plan.
We discussed the 5 options for nearly an hour.
Because Harry did not want to leave, but the statement was already prepared for him to leave anyway.
In other words, the fix was in this whole time? This summit was just for show? No answer.
So in this aspect, I could understand. Okay? In his first witness statement, the claimant says that my wife and I felt forced to step back from this role and leave the country in 2020, which correspond with his book. Although Ms. Fatima Casey drew attention to what the claimant had there said, it is common ground that the claimant's motivation for his decision is not an issue in these proceedings. I reiterate what I said at the conclusion of the public hearing on 7 December 2023. The parties have been extremely well served by their respective leading counsel and legal teams, as has the court. The hearing of the judicial review was conducted partly in public and partly in private pursuant, there's some case here, on 4 December 2023. I made an order pursuant to, there's another case here, read with the confidentiality order of Swift J of 24 March 2022. And his let me make sure. Okay, and his confidentiality rank order of 19 June 2023. In broad summary, certain of the information rely upon in this case concerned security arrangement put in place either for the claimant or for other public figures in the United Kingdom. The public disclosure of such information will manifestly have a serious adverse impact on the individual concerned, as well as being contrary to the public interest, including that of national security. To preclude the party from making reference to this information will prevent the case from being determined justly. Accordingly, the publicly available form of this judgment contained redaction. So there's some part that they redacted. Okay, the decision of 28 February 2020. So this is where Ravic had made its decision. The Secretary of State for the Home Department, the defendant, which is the Home Office. This is who Harry has issues with their finding. Okay, is responsible within cabinet and accountable to Parliament for matter of national security. This includes the protective security of members of the royal family and other public figures. The defendant has delegated responsibility to RAVEC, which is an independently chaired executive committee established to act as an overarching executive authorities for all matters relating to protective security arrangement for a cohort of individuals who are assessed to be at a particular risk from a range of threat in Great Britain. Wow. There it is here. It literally saying it, and then we've had police being let go because of their racist remark, and we have radio people who've been arrested for things, the threat that they're making against him. So this itself already, okay? But let's continue. Including terrorism, extremism, and fixated behavior. The Home Office, the police, through the Metropolitan Police Service, the Royal Household, the Cabinet Office, and the Foreign Commonwealth and Development Office are represented on RAVEC. Others, such as redacted text, so they remove that, or police forces can be invited to attend at the discretion of RAVEC's chair. Okay, the decision of 28 February 2020 was taken by the then chair of RAVEC, Sir Richard Motron, GCB. The decision letter was addressed to Hon Sir Edward Young, and later on we find out he's part of the RAVEC, the people who sit on RAVEC. Okay, then Harry made some, I don't know, there was something that was made public that Harry was not aware Sir Edward Young was part of RAVEC as well. Okay, Private Secretary to Her Late Majesty Queen Elizabeth II. The letter was headed Security Arrangement for the Duke and Duchess of Sussex. Sir Richard said, and remember, Sir Edward Young was someone they appointed. Was it Charles and Andrew wanted the old secretary for the Queen to be replaced, and they put Sir Edward Young. Okay, Charles and Andrew. Okay, keep that in mind. private secretary to the late Majesty Queen Elizabeth II. The letter was headed Security Arrangement for the Duke and Duchess of Sussex. Sir Edward said that he was writing about those security arrangements in the light of the change in roles of the claimant and his wife from full-time working member of the royal family to privately funded members of the family. Okay, again, the Sandringham part came to play, where they already had their statement ready to make public with their own decision. They made the decision for Harry.
In other words, the fix was in this whole time? This summit was just for show? No answer.
Okay, keep that in mind. And of their decision to spend the majority of their time in Canada for the next 12 months, at least, okay, that was the time they were giving them the review, okay, and then they pull the security away from them right away, okay. The letter recorded that it was understood the claimant and his wife will travel back to the United Kingdom to pursue their private charity work, and that Her Majesty the Queen may from time to time invite them to attend a royal occasion in the United Kingdom in their private capacity and to participate in family events. The letter said, as you know, RAVEC essentially focuses on redacted texts, okay, so they removed those parts, and who are considered to be sufficient risk to justify publicly funded measures to mitigate the risk. RAVEC was said to be responsible for risks arising within Great Britain as they affect principals who are in almost every case resident within Great Britain. The future arrangement for the Duke and Duchess of Sussex do not fit readily within this framework. So now they're saying because they don't live in the UK, they cannot give them that. But Harry was not asking for... What? They make it impossible for him. They really did make it impossible for him. Okay, the letter explained that RAVEC had commissioned up-to-date threat assessment in respect of the claimant and his wife. RAVEC will continue to monitor the security of the claimant's family, including through-period threat assessment. If anything should change in terms of specific threat, this will be communicated to the Home Office to establish channels with the police and redacted text and actioned as necessary. So I guess this is where they're saying they want the 28 days notice. Okay, so they could tell their dogs that he's coming so they could plan things. Oh my Lord. Giving, they redacted this part here, the Duke and Duchess the existing provision of redacted by the Metropolitan Police Service will no longer be appropriate and will be withdrawn by no later than 31 March 2020. Against the background set out earlier in the letter, there was no basis for publicly funded security support for the claimant and his wife within Great Britain and related to redacted. Okay, this is where Harry said he will pay for it. He will pay for it. But they said no, and at the same time, they cannot still provide him with that. Okay, so, God, you have that part and Harry and Meghan's covered. Okay, this is your job now. You take control of this part. Okay, the letter continues that it was difficult, however, to judge what might be appropriate without knowing the Duke of Sussex forward program or what private arrangement, if any, are being made for his security in Great Britain to link with and complement those are being put in place in Canada. Okay, so that was the idea at first. So they want to know everything that they're doing so they could plan things. It was therefore thought to be sensible to put in place liaison arrangement between HM, Her Majesty the Queen, Private Office, the Metropolitan Police, and the Home Office in order to look periodically at any forward engagement that may potentially warrant additional security attention. Sir Richard suggested that there should be a tripartite meeting to follow up these details point and in the light of the meeting. He will intend to look at what guidance should be issued about the support to be provided and the mechanism for liaison and the approval of support in individual cases. The letter ended by saying that in the light of his personal involvement in future security arrangement for the claimant and his wife, the letter was being copied to Sir Mark Sedwell. It was also being copied to, there's this here, the current chair, and redacted MPs, but not more widely to other Ravic members. So now government are involved. Both the lead up to the decision of 28 February 2020 and certain matters which post-dated it needed to be set out in details in order to assist understanding. It may be convenient at this point to name and say something about those who features those prominently in the account which follows. What I am about to say solely derives from the evidence before the court, either in the form of communication such as email or witness statement, which has been filed and served in the present proceeding. So here, this was a summary of the judge based on what he was aware of. Okay, so there's some stuff they didn't make it public, so people don't know, like me reading it and you watching this. Okay, so some important things were redacted, but let's keep in mind, not only first, Charles and Andrew removed the secretary of the Queen, and then the Syndrium meeting where the the final the arrangement for Harry wanted to give half in and half out, but at the Syndrium they made the decision for him where they already had a statement ready to be made public. Okay, so all these, the institution already had its framework, so I could understand why the judge make that decision. Okay, so the palace already cover its bases in every corners, and then later on when Harry said he will pay for it, they rejected that and all of this. So I don't think I want to read anymore, because maybe another time if I feel like I need to know more. But I think you know what I'll read though. Let me go back. Where did I stopped at the summary that the judge did. Let me go back. There's another short version. This one is shorter. This is where the judicial, after they won, so they put their statement out. So let me read that and done with this. Okay. The court and tribunal judiciary, Duke of Sussex, Secretary of State for the Home Department, press summary, embargoes until 10:30 a.m. Wednesday, 28 February. Okay. Note, this summary is provided to help in understanding the court decision. It does not form part of the judgment. The full judgment of the court is the only authoritative document. Judgments are publicly documented and are available at this. And that's the one that I was just reading. That's 51 pages. I don't feel like reading all of it. So this is giving a summary of the 51 pages, okay, that I was in, and I stepped back out. I only read the summary of the judge understanding of the case that was presented to him. Okay. So there's this here. The claimant says the decision taken by the Executive Committee for the Protection of Royalty and Public Figures, RAVEC, on behalf of the Home Secretary on 28 February 2020 is unlawful. That decision concerns security arrangement to be made in respect of the claimant as a result of his change in status in the royal family. RAVEC's decision was that the claimant will no longer be provided with the same degree of publicly funded personal protective security by the police when in Great Britain. Okay, so this is the summary of it. This is what Ravic was telling the judge. This is what they will do, because Harry is not full-time working royal, so they change his status. He will not get the same protection. Okay, funded personal. All right, so it's not public funded. Harry removed that part here. Instead of public, it will be him, but they ignore that part. Okay, so I didn't read the entire thing, what the judge was saying and everything, so let's keep it that way. 2. The claimant said the way in which the decision was reached was unlawful in a number of respects, including that the decision maker felt without good reason to follow RAVEC's own policy, and that it reached a decision that no reasonable decision maker could have reached. That is to say, it was irrational. The claimant said that he also suffered procedural unfairness. I could understand Harry. Okay, from the time at the Syndrium office, all of that, not office, meeting, Syndrium meeting, Okay, they already made their plan. They had their papers ready. They choose for him. They kick him out. Okay, which prevented him from putting forward arguments he might have wished to advance had he been aware of certain matters. Okay, the claimant submit that, claimant is Harry. Okay, Harry's team. The claimant submit that there have been unlawful filing by Ravic and the way in which what the claimant considered to be his legitimate security concern have been addressed in respect of certain visit by the claimants to Great Britain following Ravic's decision. Okay, aspect of the claimant's challenge to the decision 28 February 2020 involve what the claimant say is an unjustified disparity between the way in which Ravic has approached his case compared with the position of other individuals. So, okay, so that was the case. This is a summary of all the 51, what was presented in court, okay? Now, the decision of the court here. The court has found that there has not been any unlawfulness in reaching the decision of 28 February 2020. Any departure from policy was justified. The decision was not irrational. The decision was not marred by procedural unfairness. Even if such procedural unfairness occur, the court will in any event be prevented from granting the claimant relief. This is because, leaving aside any such unlawfulness, it is highly likely that the outcome of the claimant would not have been substantially different. Okay. Meanwhile, okay, all the other things, the threat, this thing that people been prosecuted, go to jail for threatening him and all of that. Okay, like I said, I didn't read all 51 pages. They didn't take all of this into consideration. Okay. The court has also found that there has been no unlawfulness on the part of Ravic in respect of its arrangement for certain of the claimant's visit to Great Britain following the decision 28 February 2020. Okay, so like I said, the other one, I didn't read it. It was too long. Okay, maybe at some point, if I feel like I want to read it, I'll read it. Okay, so this is the decision that they made and all of that. All right, dramatist persona and all of that. So let's go back to Twitter. Okay, I skip a lot. There's 51 pages that I told you. Maybe let me read the last page. Maybe that will be it. Okay. Ground 2 and 3 accordingly fell. Following the circulation of the draft judgment, the claimant invited the court in accordance with what he described as the guidance and as children 2007. Okay, so these are some other cases they're making reference to refer expressly to the following submission that the claimant had made in course of the hearing. First, the claimant submitted that, claimant is Harry, by the way. First, the claimant submitted that the answer to Sir James Aden KC point record paragraph 162 above, that the RMB analysis will need to be carried out in respect of everyone in England, Wales and Scotland, is that the claimant was within the Ravic cohort at the time of the decision. The Ravic had accepted jurisdiction over the claimant, and that even on the defendant's case, the claimant is in and out of the cohort. Second, the claimant submitted that it was not a matter of the RMB analysis being less useful than the bespoke approach or of the matter being categorized as either or. The claimant should have received an RMB analysis as well as individualized consideration. Third, remember, Harry is the son of the king. Keep that in mind. Okay. Second, the claimant submitted that it was not a matter of the RMB analysis being less useful than the bespoke approach or of the matter being categorized as either or. The claimant should have received an RMB analysis as well as individualized consideration. Third, the claimant says that without an RMB analysis, Ravic could not lawfully reach the conclusion that the claimant should not be treated as within other VIP category, having regard to the role and purpose of the RMB analysis. Okay, so what is RMB? Now I'm curious. It seems like Ravic made his decision. Okay, remember, I skip a whole bunch, but based on this, it seems like the Ravic make its decision without taking consideration of this. What is RMB? Okay, let me put RMB analysis. Let's open a new tab. Okay, let me pause for a second. I need to know. Okay, let me just finish with that. Okay, so I need to know what RMB stand for. If when I'm editing I find it, just look at the screen, I'll put a screenshot. None of this submission necessitates any substantive elaboration of the finding made above. On the contrary, there are further examples of the overreaching problems with the claimant, which is Harry, claimant's case, namely his inappropriate formalist interpretative of the Ravic's process. Okay, so Harry explained it above here. Paragraph 201, maybe I'll go into that. The decision of 28th February 2020 was obviously forward-looking in nature, which was the point being made by the defendant in paragraph 162. They mentioned that here twice as well, which was the in and out submission is dealt with in paragraph 178. Okay, I'll go into that. The suggestion that the claimant should have received both an RMB analysis and a bespoke approach ignores the witness evidence of the defendant, which, for the reason I have given, falls to the given weight. As already explained, that evidence shows no irrationality or other unlawfulness as regards the other VIP category. Okay, so the judge look at it, but in reality we know the threat, okay, the threat level that is happening. Okay, let's see here. For this reason, the application for judicial review is refused. So they then so Harry fell. Okay, they didn't give him the decision that he wanted. But no matter how we look at this, even if the judge, you know, reality is reality, and what had happened to his mom is a perfect example. Meanwhile, when these people refuse, God takes precedent. Okay, so let me look at some parts here. Okay, so there are some parts. Let me copy this. Hold on for a second. You know what? All of this. Let me copy it and put it in Word, just in case this is lost. I cannot open both at the same time. Oh my goodness, I was doing all of that while but anyway, so what I've done here, I've put these are the paragraph they make reference to: paragraph 162, paragraph 201, and paragraph 178. So I put them in order. 162, let's go over that and see what it says. There it is here. Okay, I have sought to follow the above and considering the evidence. The first piece of evidence is the term of reference document of 2017. The claimant, Harry, emphasized the word will in paragraph 20. Okay, I'm not gonna go into that. This document whereby the executive committee will, quote, will evaluate the risk analysis conducted by the risk management board in order to determine which individual should receive vulnerability mitigation and or protection measures. The defendant's starting point is that this document and the other later terms of reference cannot be treated as hard-edged policy document. I agree. The fact that the words in paragraph 20 that I have just quoted cannot be taken at face value is immediately apparent. If Ravic had to obtain a risk analysis from the RMB in order to determine, okay, I really need to know what that RMB stands for, to determine who should come forward in the Ravic cohort, then as Sir James Eddie Casey point out, this will apply to everyone present in England. Okay, Wales and Scotland, paragraph 20, like the rest of the document. But the thing is that Harry is not just anybody. Harry is not just anybody. Harry is the son of the king. Son of the king. They refuse to acknowledge that part. But okay, let's continue. Wales and Scotland, paragraph 20, like the rest of the document, must therefore be read on the basis that it is being used by RAVEC members, in particular, at this time, the chair, by reference to a number of value judgment. The point is underscored by Mr. Hipgrave's evident that the RMB may not must be invited by RAVEC to consider risk assessment on individual for potential inclusion within the RAVEC cohort. Okay, so let's go to paragraph 20 now, because they're making reference to that as well. I thought I had paused, but it was continuing. But let's pause and then I'll come back. Okay, so paragraph 20 is this. Simon Case was the private secretary of the Duke of Cambridge. He was not a member of RAVEC or the RMB. Okay, so let me read some of this here. Redacted text. Let me read from 17 up here. Was in 2020 a senior civil servant. Why did they remove the name? Why did they redacted this? Was in 2020 a senior civil servant in the cabinet office working with the cabinet secretary, redacted, appears to have been concerned with the claimant's security whilst the latter was outside the United Kingdom. In 2020, that issue was the responsibility of the Royal and Ministerial Visit Committee, or MV. Okay, Sir Edward Young, okay, was private secretary to Her Late Majesty Queen Elizabeth II. Remember, he was removed. Not him removed. The one prior to him was replaced. They removed the original secretary and put Sir Edward Young. Okay, as such, he was a member of RAVEC. This is where Harry was saying he didn't know he was part of it. Okay. Paragraph 6, oh my God, do I need to go back to that too? Of the 2017 RAVEC terms of reference. And paragraph 16, okay, 6 and 16 of this second witness statement, the claimant said he was expressly told that all correspondence concerning his security was to go through the royal household, specifically Sir Edward Young and Clive Alderton. Okay? So this is, I remember when this came out. And when one of those publication. Okay, 16 and was it paragraph 6 and 16. Okay, Tom Langbaker was the late sovereign assistant private secretary. Mr. Langbaker was not a member of RAVEC in 2020. He appears to have become a member by 2021. These are all Charles people. Allegedly, according to the 2021 RAVEC terms of reference, Simon Case was the private secretary for the Duke of Cambridge. He was not a member of RAVEC or the RMB. Fiona Maker-Erwin was private secretary to the Duke and Duchess of Sussex. She was not a member of RAVEC or RMB. Okay, so Sir Edward Young, this is the ones that Harry was giving information to, but he wasn't aware he was part of the RAVEC. I remember this came out. Okay, let's go to 16 and then go back to 6. Sir Mark, sorry. Okay. Sean Hipgrave is the director of Protect and Prepare and the Homeland Security Group, formerly known as the Office for Security and Counterterrorism. He assumed that role in 2019. In his first witness statement, Mr. Hipgrave describes his role as being the senior responsible owner of the government's counterterrorism strategies and objectives of keeping the public safe by strengthening protection against terrorist attack and minimizing the impact of such attack. Mr. Hipgrave states that the Royalty, VIP, and MP Security Unit, or VIP, sits within my directorate. The RVIP provides a secretariat to RAVEC. Although not personally a member of RAVEC, Mr. Hipgrave states that he is one of those responsible for informing the Secretary of State about RAVEC's work. Mr. Hipgrave attended RAVEC meetings on behalf of the Home Office and was responsible for the Home Office officials who worked in connection with RAVEC and acted as its secretariat. Mr. Hipgrave was not involved in the 2020 decision, but was involved in a decision in June 2021 concerning the claimant's visit to Great Britain. Mr. Hipgrave was in the military for 10 years and was a police officer for 13 years. He also has a background in the private sector, working with law enforcement agencies. Okay, so this is this guy they were making reference to. Now let's go to 6. There's that here. The letter explained that RAVEC had commissioned up-to-date threat assessment in respect of the claimant and his wife. RAVEC will continue to monitor the security of the claimant's family, including through periodic threat assessment. If anything should change in terms of specific threat, this will be communicated to the Home Office through established channels with the police and redacted tests and action as necessary. Okay, all right, 162, now 178. Let me pause and look for it. Okay, so I find 178. Oh, 178 is right here. An instance of the claimant's mechanistic, overly literal approach to the 2017 terms of reference concerns the criticism of the passage in Mr. Hipgrave's second witness statement, in which he distinguishes a principal redacted text for whom an RMB assessment will be appropriate and a person such as the claimant for whom bespoke consideration will be more suitable. The claimant contends that this ignores the fact that the 2017 terms of reference refer to a RMB being undertaken for the person present in the United Kingdom. The claimant's approach wrongly treats the text of the terms of reference as if the latter were an act of Parliament and ignores the position and expertise of all those concerned. The same applies to the claimant's submission that even on the evidence of the witnesses, the claimant is described as an exceptional member of the Ravic cohort, albeit coming in and out of it in accordance with the decision of 28 February 2020. The claimant says that this means even on the defendant's case, the claimant should have received an RMB analysis. This is an impermissibly formalistic stance. So too is the submission that the claimant was a member of the Ravic cohort in January 2020 and should have received an RMB analysis before being removed from it or before there's the redacted test, otherwise changed. Alright, so let's see what's the other paragraph that I want to read. 201. Let me pause and look for it. Okay, so there it is here, paragraph 201. I have dealt with this complaint above, and so far as it involved the assertion that the claimant, that's Harry, have undergone an RMB assessment, it is border formulation. The complaint in ground 6B suffers the same crucial weakness as I have identified a number of times in addressing in ground 6A. It put, okay, I don't know what in ground 6A mean. There's a lot of things that been redacted. So I don't know if these mentioned and I think there's some names that are being redacted. It proceeds from an appropriate formalist interpretation of the Ravic process, subjecting that process to an interpretation analysis which may be appropriate to some kinds of statutory provisions and statutory guidance, but which is entirely inapt for the sort of decision making with which we are here concerned. The fact that the claimant remains with the purview of Ravic and the way Sir Richard Mottram described does not mean the claimant falls to be treated. So even though Harry falls under certain things that they describe, which I skip couple things, but that doesn't mean he falls to be treated that way. Okay, for security purposes as redacted, or the sort of exceptional individual whose circumstances are such as to make their ongoing presence in the Ravic cohort appropriate. The bespoke process, the vice for the claimant, and the decision of 28 February 2020. Okay, that's what Ravic the Home Office, whatever, the one who was supposed to give Harry security, that's what they're making reference to that. And is legally sound. So they say, the court is saying it's fine. Okay, I have already referred to the witness statement of the current chair of RAVEC, who makes it plain that the claimant's visit to the United Kingdom continued to be dealt with in terms of the decision of 28 February 2020, whereby the claimant re-enters the cohort for those purposes to that extent, but that he is not treated as a principal to which the 2021, okay, well, I don't know as TOR apply, both because he is not within the cohort of and because he has in place specific bespoke processes available to him. Furthermore, the current chair explained the RAVEC redacted as to whether or not to commission an RMB for the claimant, and the current chair does not believe any member of RAVEC has suggested such a course. None of this is remotely irrational. Okay, so the thing, they agree with them, but this part, I need to know what this means. Okay, the things that I keep on finding, it has to do with currency and money and all of that. So that is it. Let's go back to Twitter and read some of the comments. Okay, I can say I'm surprised. I thought I would be upset at this, but I'm actually not. When they took the only safe home he had here, I knew they were making it more difficult for him to come here. Harry is in a better place. The case has served its purpose by exposing what was going on. The Lord will make all things turn out for good. Proud of you, Prince Harry. I'm okay with I'm not being under the protection of the corrupt Met Police. Okay, what is that? I don't know what this word here. In bed with the monarchy and tabloid, some disappointment can be a disguised blessing. This is good for Harry and Meghan. Any security would have come with caveats and favors. Royal family would have wanted them to come back at their beck and calls for every little things, and Harry and Meghan will be at risk of bully pulling the plugs as king. Also, the tabloid would have waned to come along for the ride. Yeah, there's me here. God will provide him and his family the kind of protection he deserves, yet they wanted him back in the UK for what? Okay, so that's it. Let's do a prayer. Prayer for, let's do God's protection. Okay, that's what Harry needs, God's protection. Lord Jesus, you are the highest authority, and there is no spiritual power above you. Therefore, I hide in you, as you are my safe shelter. I'm confident that in submitting to you, no evil will ever be able to conquer me. Therefore, in your name, I trust you to send your messengers and protect me wherever I go. That's it. Alright, so that's it. Please take a moment to subscribe, like, and share. If you want to support this channel, there's a PayPal link and a Cash App link in the description. You could donate. Those who have donated, thank you. Alright, so I didn't read everything, but I tried to make sense out of it. Alright, so that's it. Thank you for watching.
It is a great privilege to be with all of you today.
You know, we ask for forgiveness and please come back. As you saw me find the love and happiness that I'd hoped for all my life. You are all in this together, and if I may speak personally, we are all in this together, because asking for help was one of the best decisions that I ever made. You will be continually amazed how life changes for the better